has anything to do with them?
The Secretary is busy doing the necessary, Mr. Commissioner. We are ready to start the proceedings of this week, and our first witness is Ms. Pamela Parler, and she is ready to take the prescribed oath, or would you prefer that we sort out this irritation before we start?
It's mainly these two. It's mainly these two.
Mr. Secretary, is there any way you can arrange for the switch off of those lights?
I think the question would be, rather than doing away with them, is to turn them away a little bit so that you get the light, but they don't shine on us.
Thank you.
So I think if you just played around with it a little bit and you see how to turn them, including the middle one, but it doesn't, as long as it doesn't shine straight into our eyes, otherwise we can't see anything.
Thank you.
And we can't see the witness, but it doesn't mean they need to be off.
There we are. Thank you.
As long as your television, but then they can't see. It's too dark. So I would suggest put them on, but just adjust where they shine.
Perhaps can I ask for a brief adjournment, Mr.
Can we
Commissioner?
take, yeah, I would suggest you play around with it, but somebody needs to sit here and see that
We'll
there's
do
nothing
that.
coming into the face. And then it can be sideways or coming to you towards there so that the television has some light, but
I'm
not,
sorry for the
not blinding
inconvenience.
us.
We'll make a plan
You'll
immediately.
call us when you're ready.
Mr. Commissioner, I trust it's an improvement. We have a new crew today, and also apologies from them.
No, it's much better.
Thank you. We are ready to start with Ms. Pamela Pala as our witness, and she will take the prescribed oath. Can you stand up?
Your full names, please.
Pamela Maphakani Phala.
Give me a moment. Pamela Maphakane.
Yes.
Maphakane. Phahla, no Phala. Ms. Phala, do you have any objection to taking the oath?
No, sir.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
Raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated.
Thank you, Ms. Pala. You have come to this commission voluntarily.
Yes, sir.
You have prepared your own statement.
I did, sir.
You were not asked to put in or take out anything in your statement by any of the members of my legal team.
Not at all.
Please then proceed to present your evidence as set out in your written submission, please.
Yes, sir. I want to start and deviate a bit. I'm Senior Manager Corporate Legal within the Legal Counsel Governance and Compliance Division of the PIC. I have been silenced for too long, and I will speak from the heart, and I will do it in a manner that I know best, using poetry, which in my view depicts or portrays the environment of the PIC when I started and after change of management. If you can allow me, Commissioner, to do so.
That would be in addition to your statement, or
I will
is it?
start with it,
I
yes,
see.
in addition to
So
my
it's not already in the statement
It's
now.
not in the statement, I can circulate it afterwards, but I think it's
Yes.
a perfect depiction.
Is it
of the
something that you have taken notes on or written down?
It's
Or are you
something,
speaking like a poet now from your heart?
I love using imagery to portray situations.
Yes, thank you.
Yes. And it goes like this. It's an ancient poem. Once, in an ancient city whose name I no longer remember, raised aloft on a column, a brazen statue of justice stood in the public square, and that's the PIC, upholding the scales in its left hand and in its right a sword. As an emblem, that justice presided over the loss of the land and the hearts and homes of the people. Even the birds had built their nests in the scales of the balance, having no fear of the sword that flashed in the sunshine above them. But in the course of time, the laws of the land were corrupted. Might took the place of the right, and the weak were oppressed, and the mighty ruled with an iron rod. Then it chanced in a nobleman's palace that a necklace of pearls was lost. And ere long, suspicion fell on an orphan girl who lived as maid in the household. She, after form of trial, was condemned to die on the scaffold, patiently met her doom at the foot of the statue of justice. As to her Father in heaven, her innocent spirit ascended. Lo, over the city, a tempest rose, and the balls of thunder smote that statue of bronze and held in wrath in its left hand down on the pavement below, the clattering scales of the balance. And in the hollow thereof was found the nest of a magpie, into whose clay-built walls the necklace of pearls was inwoven. That is a depiction of the environment at PIC. I'm now ready to start with my statement. I am an admitted attorney of the High Court. I am an officer of court with high beliefs in legal ethics and good governance. I have a BProc and LLB degrees from Wits University, a master's in laws, LLM degree from the University of South Africa, UNISA, in commercial law, with specialization in company law, banking law, labor 1, and labor law 2. In addition to that, I have a number of certificates. I also have advanced companies law certificate in company law 1 and 2 offered by Professor Katz from Wits University. I had enrolled and put on hold a doctoral thesis with UNISA on the topic, employees sitting on boards of investee companies. Where do the loyalties lie? I intend to finalize my research, re-enroll and finalize my doctoral thesis in due course. After long consideration, I have decided to approach Commission. I have listened with fascination about how my character has been portrayed as both a victim, as well as a very rude type of personality. On the one hand, I have been spied on by the top 2 within the company, but as the media states, nothing seems to have happened to me. On the other hand, one of the employees has referred to me as the go-to person when it comes to labor matters of the PIC involving general employees, and therefore some sort of terminator. I am a corporate lawyer of note, known in the industry, and refuse to accept the label of victim. I will address the following in my testimony: my legal experience, my personal journey within the PIC, my ill treatment by the top 2 executives, and in my view, which was rubber-stamped by board, the structure of the legal department, the anomalies within the structure, the legal regulatory governance issues which I have been and or am involved with for consideration, that is inter alia policy on investee companies, whether PIC should change to a Schedule 2 public entity from a Schedule 3B public entity, and concerns about the PIC regulatory environment.
Sorry, can I ask you a question, which if you can't answer, perhaps Advocate Liver, you could follow up? You make reference, and we have seen in other testimony, evidence of spying on people that had been identified.
Yes, ma'am.
In what legal requirement is there, if any, for any organization to conduct such surveillance of its personnel?
I have not done legal research, but I think the RICA Act or some other law regulatory, some other legislation is applicable, but what I know is that you need to obtain consent or notify the person involved.
Just check on the legalities and compliance with whatever legal requirements there may be for instituting such surveillance on your own personnel in your own company.
Okay.
It is noted, Mr. Commissioner. We will also do the necessary.
Mr. Commissioner, the position of Executive Head, Legal Counsel, Governance and Compliance has been advertised. And the interviews, which were scheduled for Friday the 29th, have now been postponed. I have applied for the position. I am here not to influence the decision, but merely to say that there has been a lack of management and leadership within legal. There must therefore be a rethink about the profile of Executive Head Legal, the profile of senior managers within legal. I'm trying to steer the Commission and the country toward the qualities of the PIC legal department and proposed interrelationship with the regulatory compliance should be. This is because the PIC is a queer creature of statute, which is a mixture of both government, asset management, and company. So you find PFMA being applicable, Public Finance Management Act, Companies Law being applicable, FICE Act being applicable, and a myriad of other laws that surround those three key legislation. I want to agree with the various speakers that the PIC is not what it seems to be, and I will lay it here under. I will start with my legal experience. I did my articles of clerkship at McRobert, De Villiers, Lannon, and Tyndall attorneys, now McRobert attorneys. I was admitted as an attorney in 1998. Upon admission as an attorney, I became an associate at the same firm. I subsequently moved to Ledwaba Mazwai Attorneys, and after 2.5 years, moved to the Office of the State Attorney, Johannesburg, where at the time, I was the only corporate lawyer. In my second month, I was asked to manage the inquiry into the rapid depreciation of the rand inquiry, or the inquiry into the fall of the rand, acting for National Treasury, during the time where Minister Trevor Manuel was Minister of Finance, Maria Ramos was Director General, and the likes of Leseja Kanyaho, Elias Masilela, Phakamani Hadebe, and Brian Molefe. The rand inquiry was one of the first of the judicial inquiries in the democratic South Africa. At the end of the inquiry, after about 5 months at the State Attorney's Office, I was recruited by the Treasury, where I was Director Corporate Law, working on all corporate commercial matters of National Treasury, predominantly financial regulation and asset management division as my major lines. To this end, I advised the Minister on inter alia, the merger of Absa and Barclays. I consulted with the Registrar of Banks and the Competition Commissioner in advising the Minister. The exposure that I got at the Treasury was brilliant. Working at the Treasury was the most honorable position I ever had, and we were all guided by ethics and utmost good faith. I was exposed to international law, having briefly spent some time at an international law firm in New York and London. It goes without saying, therefore, that the natural progression after over 4 years at Treasury was to go to the PIC, where I was appointed as head of legal, so-called legal manager at the time. When I started at the PIC, Brian Molefe was CEO, Dr. Dan Majila was CIO, Albertina Kekana was the Chief Operations Officer, the most formidable team.
Can I interrupt you there? Can you just put a year to that when you joined the PIC?
I joined the PIC in 2006, September. A month into my position, I was also appointed company secretary, therefore holding a dual role of head of legal and company secretary at the institution. This position I held for over a year, and it is reflected in the 2007 PIC annual report, where I appear with other managers of departments. At that time, the focus was on work and not politics. There was an atmosphere of respect and engagement. Generally, employees were content and happy. Incentives were based on good performance and not personalities. Good governance was the order of the day, and you could feel a sense of belonging as you stepped into the office. Policies of the PIC were collectively reviewed annually, workshopped by all heads of department in one forum and approved in that forum. The policies were clear and understood by all employees. COO took her role very seriously. And of importance, there was involvement at the highest level in legal matters, in particular CEO and COO. The interactions with the top were splendid, and I could feel they valued us. They valued the contribution of the legal head and performance of legal as a whole. I would engage with the CIO on client mandates and external manager agreements. There was an open door policy. My understanding of basic investment management stemmed from the initial engagements and lectures that I got from the CIO. When I started at the PIC, there was no one except Jason, legal advisor. I was told at the time that the entire legal department had resigned, and there was only Jason left, for reasons that I don't know. I designed the structure of legal and employed a team to almost what it is today, save for a few people who recently joined. The legal department was a hub. I recall we had a round table at the time where we had engagements. We will just sit there and engage, deliberate on updates in law, updates on work. I want to believe that we were a very happy and well-performing legal team. A number of issues led to a drastic change in the legal department around the change of management, which in my view, led to my position being diluted. I want to believe that my role was guided by ethics. This did not go down, in particular, with the CIO at the time. I will give examples, though upon thorough research, I could not locate some of the documents on my work drive. During one of the first panel of attorneys at the PIC, in trying to develop and restructure, design a legal team, I did a panel of attorneys which was evaluated by an evaluation team through procurement. There was then a short list. CIO insisted that I must make sure that a particular firm which did not make a short list was included in the short list. I rejected his request profusely.
Just on that question, you rejected it at that time. Did that particular firm ever become a legal advisor to the PIC that you know?
No, ma'am,
No.
I rejected it. I engaged with him several times and I made it clear I do not have authority to change the short list because there was an evaluation team which was managed through procurement. So I alone did not have the power to put any legal firm that did not make the short list. Secondly, one of the few examples is a case of acting beyond the mandate, client mandate. So at the time, the PIC or the GEPF mandate did not permit or authorize investing outside of the borders of South Africa. There was a case of an investment that was done offshore. If I can recall, it was an investment in Mozambique. And if I can recall, I think it's the Cidadela di Matola. An investigation was conducted.
Sorry,
Yes.
can you just repeat the name?
I think it was the Matola transaction, something to the effect of Cidadela or Cidadela di Matola.
Can we get that information provided to us?
It's noted, Mr. Commissioner.
Just a question there. So this is different to the SNS refinery, or are they linked?
It was so long, I don't remember the facts because the files were taken away from us immediately after I provided legal opinion. So
Okay, all right,
don't
we'll
have
check
the
it out.
details.
Yeah, no, it's fine. It's fine. I think we'll.
So as I said, it was a case of exceeding the asset classes set out in the GEPF mandate. An investigation was conducted by an accounting firm, which then provided phase 1 report, a preliminary report, which, if I recall, found that there were certain breaches of mandate. Management at the time insisted that the accounting firm not conclude the investigation report and that we conclude same. I remember at the time insisting that it would be prudent for the accounting firm to then proceed with phase 2 or conclude the investigation and or obtain senior counsel opinion due to the nature of the matter. In any event, I had to do the legal opinion, and my conclusion was that there was certainly a breach. The CIO who had approved the transaction through a memorandum was was a critical part of the breach. I relied on the legal principle, if I recall at the time, of caveat subscriptor, which means that signatories beware. You cannot escape liability on the basis that you did not know or you did not have an understanding of the facts. I never knew what happened to the matter or how it was resolved. The files were swiftly taken away from us after that opinion. For reasons that today...
Sorry, you mentioned also in this paragraph that the CIO was very displeased with your opinion.
Yes, he was certainly. During an engagement with him, I could see that he was not happy with the conclusion that I reached.
And you say that he approved the deal.
He had signed off on the memo as the last signatory or approver. Yes.
And at the time, the CIO had authority to do so?
He may have authority, but that was not the legal issue. The issue was he correct to approve on a transaction that was beyond the mandate, that exceeded the authority that we had in terms of the mandate.
And the CIO was Dr. Machila?
Dr. Machila was CIO, yes. For reasons that to date I do not understand and I feel was sabotage and or to get rid of me, my position was diluted on the basis that the legal department was now to be decentralized. What it meant was that the legal advisors were to sit in the business units in which they served and reported to the heads of those business units. I asked at the time what that meant for me as the appointed head of legal. Where do my legal risks start and end? And I was informed categorically that there will be no dotted lines, no solid lines. My position then became Senior Manager Legal Services. I was the only senior manager at the time, in fact for a long time, and this meant that I was the only legal person who sat and advised in board meetings, audit and risk committee meetings, social and ethics committee meeting, which I had assisted in establishing with the introduction of the Companies Act of 2008. A number of activities occurred that took me by surprise. I was asked to do a legal opinion whereby the PIC was to change from a Schedule 3B to a Schedule 2 public entity in terms of the PFMA. The instruction came from the CFO. As was prudent from a person who provides a legal opinion, you want to understand the rationale, the strategic rationale for seeking such a change, and it was not forthcoming. I sent the legal opinion in different formats, through email, through a write-up in memo format.
Sorry, just for purposes of the record, can you explain what is a Schedule 3B and a Schedule 2 entity?
So these are public entities in terms of the PFMA. PIC as a Schedule 3B is a national government enterprise or entity. The distinction between the two is that a Schedule 3B is a juristic person. In fact, both of them are juristic persons. Ownership and control of the public entity rests with the national executive, which is the case with both Schedule 3B and Schedule 2. They are assigned financial and operational authority to carry on a business activity. They are financed fully from sources other than the National Revenue Fund or taxes or levies. And in the case of PIC, what it means that we derive our fees, we derive our income from the fees that we generate from investments that we make on behalf of our clients. Whereas a 3B is defined in the PFMA, a Schedule 2 is not defined. But when you look at the type of entities, when you look at DNL and you look at ESCOM, IDC, SABC, SAA, you find that they have the same characteristics. However, what is added to a Schedule 2 is that they have a strategic public function, which is evident in their respective pieces of legislation and which you do not see clearly in the PIC Act. So what you find in those pieces of legislation of the PIC establishing IDC, ESCOM, SAA, etc., is that you find a clear objective. Over and above that, there are ancillary objects which allow them to carry out other activities. That is not clear in the PIC Act. So in seeking the opinion, I mean, I did it myself and I could not find any provision in PFMA regarding a change from a Schedule 3B to a 2. I then engaged with the Treasury Asset and Liability Asset Management Department, Legal Department, just to be sure. In situations such as this, where I feel I need confirmation, I then go further and engage. I then also engage without cost with an attorney who specializes in SOE governance for guidance on the matter. Through interactions on email, I could see that CFO was not happy with I concluded that the CFO was not happy with the format in which I presented the opinion. And therefore, I did the legal opinion in a presentation format in the methodology of a thesis, starting with a hypothesis. I then confidently went to see her to discuss the opinion and or to obtain further requirements. And what she said to me was that Dr. Dan doesn't like you. Dr. Dan wants Ernest. What she also said was that you don't have to do the opinion. I'm going to ask Ernest. What is interesting about that was that I have never seen Ernest do a legal opinion or conduct research, despite the tools that we had internally.
Can you just, for the record, the CFO at the time?
Matsepo Mori. What she also said was that, in fact...
Just let me refer you to that quote. Dr. Dan doesn't, you said, like you, but
she
you've written
said
there,
something...
want you. I don't know whether that...
Yes, she said Dr. Dan doesn't want you. Dr. Dan wants Ernest. I remember jotting it down at the time.
Can I just, in relation to this matter, in what you've presented as the work done on the Schedule 2, Schedule 3 matter, you make a point there, the PIC runs a big risk of being accused of acting ultra vires its objective should it continue making transactions as principal. Can you elaborate on that? Because clearly under what it exists as in terms of 3B, Schedule 3B, it can't act as principal.
No.
And has it been doing that?
So
and you give us some examples where it has been acting as principal, which would require it being a Schedule 2 company?
That quote at the end of my presentation refers to the object of the PIC. If you look, I think it's Section 2 or 4 of the PIC Act, it is very clear that the object of PIC is to be financial services provider, and it ends there. And I compare it with legislation of other public entities, especially Schedule 2 public entities, which are very clear and succinct in the sense that here is your object, and these are the ancillary objects that you are allowed to do. The PIC Act is very succinct as that. You are financial services provider in terms of FICE, and what clearly that means is that you are an agent acting on behalf of clients, nothing more, nothing less.
No, I appreciate that, but what I'm querying with your point here, which is, the pages are not numbered, but it's almost to the end.
Yeah.
The PIC runs a big risk of being accused of acting ultra vires its objectives should it continue making transactions as principal. That assumes, from the way I would read that it has been making transactions as principal.
There may be examples.
Can we check that, Advocate, and see if there have been examples of acting in terms of principal by the PIC? Because
it's noted.
Thanks.
Yeah. So basically what it means, you can only act as principal and nothing else. And I had suggested at the time that we change that and add ancillary objects which were clear with regard to what else we can do. Around that time, or shortly thereafter, Ncedisi Jonas took over as chairman. Dr. Dan was CEO. I remember attending a board strategy meeting and was surprised that Whereas I've been the sole person who has been attending strategic sessions at board from the legal side, Ernest Nesani, who I had appointed as junior lawyer, was one of the speakers.
Tell me, you referred to the chair as Mcebisi. Is his correct
Mcebisi.
name not Mcebisi?
Yes, sir.
Mcebisi Jonas.
Mcebisi Jonas.
I think
Thank
so.
you. He took over as chairman. Dr. Dan was CEO. Ernest spoke on behalf of legal, and I was perturbed about in what capacity was he presenting as legal was decentralized. And I had been the only person who had been, so I had not been warned about it. He was very clear in his statement that we are going to be enablers. We will not just sit here and say we can't. Shortly thereafter, sometime late in 2015, Dr. Dan called a staff meeting where I confidently sat in front in the boardroom, Mapungube boardroom. The positions of executive heads were introduced. Acting executive heads were also identified and introduced.
You missed the previous sentence.
Yes, sir?
He indicated. You missed that sentence.
Oh, so he indicated that there will be a restructuring within the company. Positions of executive heads were then introduced as part of the restructure. Acting executive heads were then identified and introduced at the meeting. So the people who were heads of departments automatically became acting executive heads at the time. Dr. Dan introduced Nesani as the acting executive head legal. What he said was, I want to fix that legal department. At that point, my mind went into a daze, as can be expected, and I felt all eyes fell on me. I tried to compose myself and look fine. Then I heard him say something like, as my mind was in a daze, I don't remember the chronology, about leaving to form a Macheka Attorneys, Macheka Incorporated. I had started at the PIC as Pamela Macheka. What I did not state here was that I had just gotten divorced. I was going through a personal crisis, so the timing of it was unfortunate. So whereas I was not going to change my surname, Macheka, because the industry knew me as Macheka, this prompted me to change my surname to my maiden name, Phala. When they advertised for the position, I did not bother applying, having sensed that the top two clearly did not want me at the institution. I was bruised, but did not let that destroy me. So I went to see a coach as a corrective measure to help me deal with the dilemma strategically, and this reinvigorated me. What she said to me was that you may not leave the institution at this moment when you are at a low. Redeem yourself, prove yourself, and then you can consider your options at that time. That helped me to carry on at the PIC. With Nesani now as executive head, the strategy was changed from a decentralized legal department to a centralized legal department. The decentralization, which was the decision of management at the time, had damaged the legal department as a unit, which is to date, in my view, still fragmented. I continued to manage the corporate legal department under the leadership of Nesani in the position of senior manager corporate legal, and for some time as the only senior manager in the unit. During this time, in a quest to get rid of me, Nesani sidelined me, preferring to go directly to my subordinates. I got to learn from one of the team members that he had promised my immediate subordinate my position if she supported him in trying to sideline me. This continued for some time, until they realized that their exclusion of me was not going to make me leave. I continued to do whatever work I had, and I did it well.
Can I interrupt you here?
Yes, sir.
You testified that you appointed Nesane into the legal department.
Yeah.
Is that correct?
That's correct. I appointed him as a junior lawyer.
What was your relationship with Nesane after his appointment?
Excellent. We worked very well together. And in fact, what he used to do was to tap my back and tell people, I am what I am because of this lady. You see this lady here? I am what I am because of her.
And when did the relationship change?
I think the decentralization meant that we then became apart. So it never really changed. He just became a different person.
Was there ever a discussion between you and Nesane about the dilution of your position and him now going up to be the acting executive head legal? Did you discuss it with him?
No, there was no engagement. In fact, I remember walking with him at the old building from Block A to Block C, and he said something about that we talk about parting ways.
Thank you.
So I continued to do whatever work that I had quietly, and I did it well. At that point, when Nesane took over, he indicated that there was no need for me to attend committee meetings, and that's board, ACC, and SEC. What he said to me was, I'm here now. And at that stage, I was the only senior manager, still the only senior manager in the whole department. Yet, I saw my peers, who were junior in positions, attending the most important committee meetings. I'm speculating that his actions were clearly a directive from the top, and in my view, including board, to get rid of me. That is, if I am sidelined, I will leave for sure.
Sorry, can I ask you, the implication here is that Nesane or others then attended board meetings and so
Yes.
on. Was that correct?
That is correct. I had stopped with effect from 2015 from attending board meetings, SEC, and Audit and Risk Committee, which I had attended from inception.
But he now attended?
He said, I'm here now. I will
Yeah,
now
that's what he
attend.
said, but he actually attended the meeting, so he was legal advisor to the present in those meetings?
As executive head, it
Yes.
was prudent for him to attend. As to whether he attended or not, I don't know. He never gave us feedback.
Can we check the attendance to see whether in the board, particularly the board meetings,
It's noted, Commissioner.
that's the exec head legal actually attended? Because I'm interested to see the role of the legal counsel in relation to the decisions taken by the board.
The leadership of Nesane was havoc. It was fraught with favoritism and exclusion of me. He had his favorites. I continued to contribute to committee meetings, almost every committee meeting, even though I was not permitted to attend. I had a feeling sometimes that he did not read my submissions, but trusted me to have done my job well. He will look at my submission and see some sort of graph, and he will say, that's good, and he will sign. As a division, we were now centralized, but not united. We had no legal meetings. To date, we have not had a legal meeting since he took over. No one-on-one meetings, no deliberations on legal matters. The only meetings I remember as a team were for HR scheduled meetings with divisions on mainly of the PIC, mainly to report back on incentives. I recall one meeting, interesting meeting. It was Nesane's birthday party on the 3rd of November. The meeting was very impromptu. We were invited and asked to come to a boardroom within 10 minutes to celebrate his birthday. And it was called at short notice. PA bought a cake. He insisted that people get out of meetings. I recall he would say, where's Moja? He's in a meeting. Can you ask him to come here? He must get out of the meeting. Where's Sasa? Can she please come here? She must leave the meeting and come here. Once most of the team members were there, He then said at the meeting, raising his hands, that this is my empire. Such was the nature of the leadership, that he was hardly ever at the office. There was no room for engagements, no team meetings, no discussions on anything, including updates in the law. I want to believe that he just signed my memos to committees without reading. Maybe he trusted me with my area of law, I don't know. During his tenure, I saw my juniors being appointed to acting positions when he was not around, despite my being the only senior manager in the department. Such conduct could only have been, in my view, rubber-stamped at the top. I have contributed strategically in many ways to governance at the PIC, albeit I was not permitted to attend committee meetings or strategic meetings, even though my colleagues at the same level or junior attended strategic meetings and applicable committee meetings. I was relegated to attending the IT and risk committee meetings. I was not permitted, and neither do I still attend, audit and risk committee meetings, even though I submit reports at almost every meeting. I once met the current deputy chairperson of the PIC in the corridors, and I introduced myself, and he responded that, oh, I've seen your submissions at board. I have also seen my peers, including juniors in compliance, risk, and audit departments attending audit and risk committee meetings. I have seen over the months my juniors acting as executive heads, Setsedi and Sasafako, who immediately before Nesani departed were swiftly appointed senior managers. Both were appointed acting executive head during Nesani's tenure when he was not around. Not once was I appointed to act when Nesani was away. With the departure of Nesani due to the VBS corruption, Setsedi, who is another person that I appointed and developed, became acting executive head. She used the same style as Nesani, no meetings, no engagements, birds of a feather. She was subsequently removed, and Lindiwe Dlamini, senior legal advisor, who was much junior, who I also developed and appointed. She joined the PIC, started at the PIC a day after her admission as an attorney. She was appointed acting executive head, legal counsel, governance and compliance. I had appointed and developed all of them, save for a few, including Sasafako, who started later. My work has over the years focused on corporate legal, governance, regulatory, employment law and litigation. I had absolutely no involvement with deals, no engagements with the CEO and CFO save through memoranda, no reporting to committees. My work was, however, accepted and considered in respect of submissions. I could see activity on my laptop when I was busy working, whereupon I will sit back and fold my arms and allow them to continue spying. My name was splashed in the papers as one of the top 6 who were spied on, albeit with the remark that nothing seems to have happened to her. Of course, nothing could have been found on me. I am an officer of court. My view is that they were trying to find something, anything, to nail me so I could be dismissed. I then go on to deal with the structure of legal and challenges with leadership and the anomalies.
Question?
Yes, sir.
I just need to understand, it seems that there was some major fallout, between you and the top 2. I mean, maybe if you could come again on that issue that, what happened, what could have happened, what could have been the issues?
Sir, I don't know. I did my work diligently. I did my work ethically. Sometimes I feel that when you believe in ethics, you don't belong in corporate. I almost feel you are in the wrong place. So To date, I don't know what could have happened. Maybe they wanted to put their own people who will support their views and their business requirements. I don't know.
Perhaps I can follow up on that, Mr. Commissioner. Did the CEO or the CFO at any time called you in to say we are not satisfied with your work or the quality of your work?
Not at all. I must say that I'm one of the few people who write very well at PIC, so I've put my facts categorically. I enjoy doing legal research. I notably don't necessarily go and engage with external counsel unless it's very technical. So I am confident about my corporate legal skills. So I do not know, once again.
Just as a follow-up then, when you refused to appoint the law firm that the CE said you should do you think that could have been the beginning of the fallout?
It was a series of events, in my view, of my acting ethically, of my not necessarily being a yes man, in my view. In fact, around that time, he said to me a few times that, don't you think it's time that we got a younger person? So I would love to know one day.
And what could have caused some fallout, some seemingly, some fallout with the CFO then? What could have been the issue there when she said, Dr. Dan doesn't want you here?
She wanted an opinion that said, yes, it's easy to change. It was not easy. There is nothing in the PFMA that allows us to change from a Schedule 3B and 2. She wanted an opinion that said, yes, it is possible, and we can do it now. It was not possible. I had interrogated the matter. I have engaged with specialists on the matter, and I was confident it wasn't possible. I said, we can do it, but only if we continue to change the PIC Act and include, as was the case with the SAA, that they were a subsidiary of Transnet, and when they became its own entity, they then inserted in their act a provision that stated that they were a Schedule 2 public entity. So I did not necessarily say, no, you can't. I said there are mechanisms in which you can do it. So perhaps they wanted an opinion or opinions over the years that said, yeah, it is possible. That's not how I operate.
So that could have been the start of the fallout with the CFO then? Possibly?
I don't necessarily feel it's a fallout, and I am not going to agree to a label that I'm a victim. I almost feel like it wasn't about me, but it was about getting somebody who will enable what they want in whatever manner. I think so. Yes, I'm speculating.
Yeah, all right. Okay.
Mr. Commissioner, it's almost tea time. Would you like to take the tea break now, or shall we continue with the next topic?
Let's see how far we can go.
I got the impression that, where am I? Okay. Paragraph 8. Structure of the legal department, its challenges with leadership and anomalies. The legal division has the following sub-departments. There's corporate legal, there's regulatory compliance, there's labor law, properties legal, listed investments and unlisted investments. I am Senior Manager Corporate Legal, and I have assumed over and above corporate law responsibilities for senior labor lawyer regulatory compliance as well.
So shall we change was to is? You are, I am.
I am.
Yes.
And in addition, so that in the structure here, there is no distinction between the legal department with all of these different specialities and areas of focus to a legal counsel, which is overall responsible to the board or with the board, with the CEO, that advises on the general legal frame within which the PIC office operates.
So
there's no legal counsel that is distinct from the department.
No, that's the executive heads who would be counsel for board. So under that position of executive head, there are sub-managers.
Yeah, I understand that, but in essence, if I had to look at it, you'd often have in an organization, you'll have a legal department with a head of department that looks at all the operational issues, and you may well have a legal counsel which looks at the wider framework within which an organization operates. The PIC has not, while you've been there, had a legal counsel.
No, not at all. So I took over those responsibilities over and above my role as corporate law senior manager. This has presumably been due to my interest in corporate law, labor law, governance, litigation, and interpretation of laws. As indicated above, the legal department is not in unison, as we have not had effective leadership since Nesani took over. Nesani seemed to have interest in investments. When Nesani left, Sitsedi seemed to be overwhelmed by acting executive head role and was somewhat of a bully. Dlamini, in my view, is so junior. She is a yes man who clearly takes instructions from certain board members who, in my view, unnecessarily get involved in management issues. Dlamini, with due respect, in my view, fails to think independently and has over time tried to please select board members. She is also a specialist investments person.
Are you able to give us some examples of the interference by the
Yes.
board into management matters?
Yes. Victor Siani case. Initially, when it started, I gave the view that the matter is under consideration by the commission, and therefore it would be premature for us to do that. She insisted. What I actually proposed to her was that let's together go to Advocate Lebe and get a view on whether or not we should proceed. And she was insistent on, we have to proceed, we have written to Lebe. As she was talking, I could feel that it wasn't her, but it came from somewhere else. In fact, he has written to us, he's made it clear that it's a management issue and that we should proceed. There were a number of times when I went to her office and her phone was on speaker, and you could hear board members talking to her. And I was perturbed at the type of instruction that they gave to her with respect of operational matters of the law.
That's very recent, isn't it? That's a very recent activity.
That is recent, yes. And get affidavits. I mean, this is a job of a legal counsel too. A board member sits there and makes decisions in unison with other board members. Board members single-handedly cannot contact you as an in-house legal counsel to give a view, albeit that you are an attorney sitting on board. You do not have a right to interfere and advise me on what legal steps to take. I will consider the matter strategically, and I will engage with you on how I decide the matter should be carried on.
Can you indicate the name of the board member that was acting in this manner? No, we're asking you to do that. It's not...
So I went into her office. Ms. Zulu phoned. The phone was on speaker. It's just the manner that you engage with a legal counsel. The interaction surprised me. It's just the manner in which you talk with a professional head of legal at work. It just perturbed me that they could get deeply involved in internal matters in that fashion. They have taken over Victor Siani case from us. In fact, it appears that my advice has now been taken by them. And another board member who I shall not name phoned through when I was there. The phone was on speaker. Board members should not be involved in operational matters of the PIC. Their role is to act in terms of the fiduciary duties in unison with other board members. That is a governance principle. I felt my role was not respected. Nesane jumped me and would go directly to my subordinates. Such has been the practice within legal even when Nesane left and CCD took over. This, in my view, signified disrespect to my authority as manager for corporate legal. If you do not respect my role, how are my subordinates expected to respect me? Several matters were hidden from me, yet they will go directly to my subordinates who reported to me. I made monthly submissions to EXCO board and board subcommittees, but I was never called, and I'm still not called. Yet, I'm asked to attend to urgent strategic matters because they have faith I can do it. This therefore calls into question the profile.
Question here. Yeah, question here. If you could explain what do you do at corporate legal? What is the work you do there?
Investment management in terms of doing client mandates. I used to do external mandates, but now they lie with listed investments. The executive head of listed has made it clear that I am not to get involved with his work. In fact, he called anybody who asked me, who had faith in me to assist with legal advice. He called them to a meeting and warned them that he will take action. So I do all corporate commercial matters. I do agreements. I do litigation. So I think in brief, anything other than deals, I will be responsible for.
Thank you.
This therefore calls into question the profile of the executive head legal. Should a specialist be appointed? Or should a leader be appointed? I think these are the issues that I feel the PIC board and management need to consider. The profile of senior managers within legal should also be considered.
The question there, did you want to do deals? Because you are not doing deals currently.
There were people who were appointed to do them. So I was not involved.
But
I'm sorry?
Was that from the beginning, or did you do them first and then changed?
At the beginning, I was head of the legal department, and I appointed specialists in that regard. So I oversaw everything that occurred within the legal department until the change.
Oversaw everything, including the deals that they would be dealing with, the people
All
that you appointed.
Yes, sir, all activities of the legal department I was responsible for. So I am saying this calls into question the profile of an executive head position. The profile of senior managers should also be considered. And this is also due to the changing regulatory landscape of financial institutions and the strategic growth of the PIC. There are other anomalies that are concerning. Executives, especially HR, engage directly with attorneys without legal's involvement. I noticed the trend that we will merely be asked to attend to procurement and then they swiftly take over. This meant that legal fees are not properly managed.
Can I interrupt you? Is this in line with the existing policies of the PIC, or is it in breach there?
We do not have a legal policy since Nesani. Initially, when I started, I had a legal policy that made it clear that business were not to appoint attorneys or engage with attorneys without the presence of a legal person. I made it clear to the attorneys on the panel in their contracts of appointment that in the event that they do that, I will not sign off on any invoices. So it seemed to work well.
Are we talking about outside attorneys now?
External attorneys, yes.
But we heard last week about some procurement process in the legal department. I mean, someone said there is a process and a framework around that.
We don't have a legal policy. I've never seen it. The last one that I saw was years ago when I said, I've never seen it. They need to produce it and show it to me.
Well, let's ask you, sorry, Mr.
So are you saying that you do not have a database of approved legal firms?
We have a panel of attorneys which after procurement process was followed. That is a list of external attorneys appointed in accordance with a number of categories, areas of specialization. So in the event that we need to appoint an attorney, we will seek quotations from that panel, from that specific, if it's labor law, we will get quotations from and appoint from that panel.
To ask a practical example, for instance, if there's going to be a disciplinary hearing of employee A, can HR then directly engage with the law firm and appoint them and appoint senior counsel to chair the disciplinary hearing, or must it go through the legal department?
That process needs to go through the legal department for efficient management of legal costs as well.
And what you're stating here in paragraph 8.5.1, the tendency now is that HR now engage directly with attorneys without going through the legal department.
That has been the recent practice. And this means that fees were not properly managed, and the legal fees then became exorbitant. I have noted that board has also been doing the same, get involved in management matters, get attorneys briefed and run with it, excluding management. The anomaly is that as per delegation of authority and depending on the amount, I then have to sign off on invoices through the system that we have, Great Plains. In respect of matters, none of us at legal have been involved in. And there is a recent scenario where a procurement process cannot be verified and accounts have to be settled, and I have been pushed to sign off, which I've refused. Centralized or decentralized model of the PIC. I have experienced both centralized and decentralized models of the PIC. I have preference for a centralized model. Business may view a centralized model as a problem in the sense that they may see it as running it like a legal team, a law firm. But if run well and with good leadership, risks will be managed effectively. Legal risks are better managed with a team sitting together and strategizing together. The risk of a decentralized legal model where legal teams report to a business head means that there is no segregation of duties. Legal will fear providing independent legal advice, and the business head does not have the legal qualifications and experience to advise on or sign off on issues of the law. This in itself is a risk to business. What model would be suitable for PIC? I'm making a proposal here that having been there for a number of years, both in a leadership role and from an eagle-eye view having been shoved aside, my view is that the model best suited for PIC is a centralized model which has a split between corporate function and investment function due to the different expertise and volumes of work involved in both areas. And my proposal is that this may entail having two legal heads due to the nature of the PIC, reporting either to CIO and COO respectively, or I'm proposing that there be an executive head with general manager, corporate legal, and investments legal, both reporting at that level, at that senior role, reporting to the executive head legal. I'm setting out here in paragraph 10 strategic governance projects that I've been involved in, cases and regulatory compliance at the PIC. I've dealt with a change from Schedule 3B to a Schedule 2. And I'm asking that perhaps the Commission may make a recommendation to propose that through the PIC Amendment Bill, the PIC should be classified as a Schedule 2 public entity. I also deal with a framework and policy on investee companies, and I would love to address this into two aspects. I want to deal with the precedent-setting case on board fees that I had dealt with, and secondly, with a framework on directors of the PIC and employees sitting on boards that I managed with the CFO.
Yeah, a question. Yeah, a question.
Yes,
Just going back to 9.4, just come again there because you are speaking about CIO, COO, and then from there you are talking about general manager. Just come again there.
I'm
Let's
saying
understand.
due to the nature of the PIC and the volumes of work and the level of expertise required, I'm making two proposals, either or. Yes, sir. So the first one, I'm saying that there be two heads, one responsible for investments, the other for corporate, reporting to CIO or COO if it is introduced. Alternatively, I'm proposing that we have an executive head, we retain it, but there be two senior general managers at that level, who one will be in charge of investments, the other one in charge of corporate law function.
So if there's a CIO and a COO function, would the corporate report to the COO?
Yes.
And the investments one reports to the CIO? Is
Yeah.
that
The
what
na-
you're saying? Is that what you're
That's
saying?
correct, sir. That's correct. The nature of the role of executive heads is that they are hardly ever there. They go from one meeting to another. So you need somebody at that level to then assist with the role, the respective roles, yes.
And then the second proposal is that if there's no CIO or COO, you are saying then what must happen?
I then propose that we retain the role of executive head, but then we have general managers at that. Currently we have EH, and then we have senior managers, and everybody's doing their own thing. And I'm saying that for efficient running of the department, perhaps what should be introduced is general manager for corporate and investments, who the EH can rely on strategically on the various issues.
All right. Yeah, thank you. Thanks.
Let me just stay with this question about the Schedule 2 and the Schedule 3B. If I understand this correctly, that in essence being a Schedule 3B, and in terms of the PIC Act, it is restricted as a financial service provider and can act only as agent. The question of Schedule 2 changes the ability to borrow.
There are
And the principle, that key difference between
there may be aspects of remuneration. I don't know if it's that Schedule 2 have an advantage in that case. From Treasury Asset Management to come in and explain the difference between the two. They have an advantage of perhaps maybe not getting approval from minister in that regard. There are a number of aspects into the difference, which I had tried to probe the CFO but could not get a sense.
in essence, PIC and not to the individual.
So board fees were indeed paid and bonuses were paid to the PIC. The argument of PIC at the time was that transactors or people who sat on boards were remunerated sufficiently to cover those type of activities.
No, I understand. I just wanted to be clear that the fees were actually paid.
Yes, ma'am, yes. The PIC won the case at the court or the court of first instance, and the employee took the matter on appeal at the full bench, comprising of 3 judges, and PIC, and the employee was successful. The PIC board was then almost divided on whether or not the PIC should appeal the matter further to the Supreme Court of Appeal. So it was difficult to get them to commit with regards to whether or not we should proceed with the appeal. For me, it was significant that we appeal, and in a way, they left it to me to decide and basically made it my risk.
Sorry, just for clarity again, when did this occur? When did this case take place? The year?
We can check, I'm sorry.
We will check the year and we'll come back later in the day with that.
Yeah. The PIC was successful at the Supreme Court of Appeal. Employee took the matter to the Constitutional Court on the basis of an infringement of his rights in terms of the Constitution. His referral to the Constitutional Court was dismissed in costs even before it was considered. The former employee therefore became liable for tax costs from the Court of First Instance until the Constitutional Court, which
I don't think that like it when you say before even being considered.
I'm sorry.
Just to
before it was deliberated by the parties.
I think the technical point, Mr. Commissioner, as you correctly pointed out, for leave to approach the Constitutional Court on this issue was dismissed. It was
trading, the cessation of we propose taxation for employees and directors from sitting on boards in respect of listed investments in South Africa, but that they may sit offshore. Representation in respect of listed investee companies should only be in the form of a pool, from the pool of third parties, and that PIC employees were not to receive any remuneration for sitting on boards. Personal directorships, that we said that employees should obtain approval from the CEO. Another significant matter that I worked on was disclosure of personal financial interest. I have attached.
Before you deal with that, and I hope I'm not catching you by surprise, but we have heard evidence in this commission about the concentration of power within the offices of the CEO and the CFO at the PIC at the moment. What is your view as a legal person on the CFO and the CEO sitting on boards of investee companies?
If you have a view.
I don't have a view. I don't know. But I think if they still follow the framework that was approved at the Directors' Affairs Policy and the requirements are adhered to, there may not be a problem.
A question? Yeah. Let me get a view from you, if possible, please. So, directors of the PIC, they sit on the boards of these companies, and in some ways they get, payment for that. And then the fees at the PIC seem not to be enough, they augment each other, So do you think that the PIC should take away their fees and pay them more within the PIC, or this should stay the way it is?
Sir, I don't have a view in that regard. I think the person who works closely with that, I have not been attending board meetings, and so I really don't have a view in that regard.
Okay. Do you think the normal board fees at the PIC are sufficient? Do you have any view on that?
Board fees need to be paid to non-executive directors. Board fees should not be paid to employees of the PIC, including executive directors.
Because that's part of their job, attending board meetings. It's part of their job, isn't it?
Yes, sir.
Yeah.
Yeah, wait. I'm just trying to find something here. So, the PIC board people, do you think the way they are being paid now with two sides is the correct way?
With two sides, in what respect?
Sense that they get money from the companies where they are nominee directors, and they get payment from the PIC, the normal work which they do for the PIC.
Perhaps a benchmark needs to be done in that respect, with regards to other SOEs, how they do that. Companies like IDC, perhaps, DBSA, how they manage such a situation. I have never really considered such an issue.
Because my concern is that, for boards to do good work within the companies, they need to be paid relatively well, to spend enough time, to do good work, So I would be worried if they're not paid enough for the time they spend today.
Yeah, I think as a matter of principle, I do not see anything wrong with them being remunerated for board attendances.
But just as a point of clarity, that, as I understand it, non-executive directors are paid for their work on the PIC board, but any director sitting, an employee of the PIC sitting on a board, does not get paid. Those fees go into the PIC.
That's correct.
And if it is a board member, a non-executive board member sitting as a nominee on another board, do they get the fees, or does the PIC get the fees?
If it's a non-executive director,
they get the fee.
They get paid.
So they get paid for sitting on the PIC board plus any other board that they may sit on.
Correct. What I said to Advocate Leber during break was that after the we were successful in the Kahiso Budihelo case, I did not feel any excitement from the PIC, and I got to learn afterwards that they would have preferred that they be paid. Perhaps it's something Commission should consider as well. That despite the decision of court, perhaps because of the nature of the PIC, employees should be paid for attendances as nominee directors.
The time they spend at those meetings is time that they could have spent.
That they should be at, and they get paid sufficiently. Investments people get remunerated sufficiently at PIC. I will not deal with the disclosure of personal financial interests. I have attached the legal opinions.
Sorry, can I just ask whether there is an evaluation in relation to the non-exec directors? We're talking specifically now non-exec. If they serve on the PIC board and a number of other boards as nominees, is there ever an evaluation as to what percentage of their earnings comes from working on the PIC? Because that's got to affect their ability to be independent. If you're an independent director, an independent non-exec director, and dependent on your fees for your income, it's got to affect your ability to be independent. And therefore, it may be what you do, but then you should not be classified in the recording as an independent director. You should be classified as a person who's a non-independent director. Is there anything in the work that you've done in relation to the board that, if you like, classifies the independent director and the non-independent director in relation to the extent to which they get board fees, whether directly PIC board or nominee positions?
When we did the framework, we did an analysis of who sits where to get an understanding of how much time is spent attending, especially on the part of employees. I don't know how it was taken further, but that analysis has been done, and I propose that it should continue to be done.
Can we also find out in relation to the non-execs how much time, because it would relate again to time, how much time is spent on the various boards that they serve on, and in relation to that, what remuneration they get, because that must help determine whether they are independent or non-independent, and that would then assist us in understanding the relationship or the numbers in relation to the board of independent directors, non-independent directors, and so on. I think it would just help us.
It's noted, Commissioner. We will definitely do so.
Ed? Can you give us a sense in terms of numbers of the boards that the PIC sits, say on the listed side, roughly? I mean, we know there are like top 40 companies or top 60 companies on the JSE.
I don't know.
We'll get.
Mr. Commissioner,
there should be the right person within the PIC who can provide that.
we will get the statistics for the Commission.
Okay. Disclosure of personal financial interests, I will not deal with it at this session. I've attached legal opinions. I have submitted them. I did not get consent from the author of the opinions, but I've attached them for your reading. The PIC regulatory framework.
But, sorry, just to say, you're not reading it, but you're confirming its correctness.
Yes.
The paragraph that you're not going to read.
Yes. I will now deal with, another strategic factor, the regulatory framework at the PIC. So the PIC has 2 regulatory compliance departments. There is the compliance officer sitting within risk, and there is a regulatory compliance sitting within legal. I had inquired at the beginning from Nesani what the strategic role of legal is in respect of regulatory compliance, and I never got a response. From the PIC compliance officer has insisted that he's only responsible for the FAIS Act. He also indicates that his role is independent and that his role is to monitor. So no meaningful engagements have really taken place in that regard. From the legal role, we just continued to do what we thought was suitable. We have a system which sends out regulatory alerts on a daily basis on updates in the law. We have a regulatory universe which we update every quarter or biannually and table at committees of board. We have procured a CRMP in an attempt to digitize the regulatory process at PIC. And we started with a few, about just less than 10 pieces of legislation. This has not been effective due to lack of engagements.
Can you just explain to the Commission what is CRMP?
It's a compliance risk management plan. We project manage implementation of new laws. We have a training plan for the year. We invite attorneys with specialization to come and present to us. We also invite regulators to come and do the various presentations on their respective acts. Recently, we had hosted the National Treasury and the FSCA in respect of the coffee bill.
What is the coffee bill?
Conduct of Financial Institutions Bill. It is going to replace the FAIS Act, all the laws pertaining to financial institutions. I want to believe that the PIC regulatory framework is haphazard. It's not supported globally. It's not taken seriously by board or anywhere at the PIC. There is no engagement around it. I think the focus at PIC is more on investments than on the regulatory part. I don't believe that it is supported globally, and that is through engagements with other specialists in other entities, financial institutions, some of whom have done a global benchmarking. It needs to be attended to as a matter of agency. I have made a proposal in that regards. PIC is a complex entity with a number of laws that apply to it. And therefore this area within the business of PIC needs to be taken very seriously. The coffee bill is introducing market conduct, which means that there will be a move away from the rules-based approach to a principle-based approach. Thus, the mere fact that you can tick all the boxes in terms of legislation should not be sufficient, and therefore the focus will now be on culture and ethics. And I've spoken to a number of financial institutions, some of whom have done this international benchmarking. I have also been considering the coffee bill, which introduces a culture-based, a conduct-based approach.
Sorry, can I just ask for clarity? The document you're reading from is...
It's just my summaries. Which
okay, if you can ensure that that's handed in to
I'll
the
hand
evidence.
it in, yes, ma'am. The current framework of the PIC, it doesn't work, and it may lead to gaps. I have also done a comparison. I've looked at Regulation 49 of the Banks Act, who are the prudential authority, and I find that their approach is clear and succinct. The coffee bill is also not clear, and that's one of the comments I'm going to submit to the regulators in that regard. Regulatory compliance cannot only focus on fines. There needs to be a strategic framework in that regards. So the view of compliance has been, ask legal. I mean, we were audited on this aspect recently and they said, ask legal. And we said, ask compliance. So I'm proposing a number of steps. We have myriad of legislation. We are unlike any other asset manager in the country. We government, we asset manager, we financial institution, there's thousands of other laws. The PIC regulatory universe has over 100 pieces of legislation that apply to it. I'm proposing a unit where there are subject matter experts. And I'm proposing in respect of the categories data and privacy. So at the moment I do everything with limited staff members that I have. I have to look at implementation of POPIA, data and privacy. I have to look at section by section of each new law, and we cannot keep up. And that is a big risk to the business. So I'm proposing categories of subject matter experts on data and privacy, on financial regulation, on FICA, that's money laundering, on governance pieces of legislation, that's IT governance, that's Companies Act, that's King 4 and other pieces of legislation that fall under governance. Those people will read the pieces of legislation as they come in, including existing legislation, do a section by section analysis of the legislation, do an impact analysis and engage with the business throughout, continuously. The principle that comes out of the coffee bill is treating customers fairly. So the strategic approach of the PIC should now shift because of the introduction of that coffee bill to treating customers fairly. I'm proposing that those subject matter experts, instead of having a system which we have to understand, that they do the CRMPs in respect of the legislation which fall under them as subject matter experts. I further propose that there be step 2 risk managers that will fall under the risk and compliance team, monitoring as well. With regard to learning and development, currently that falls under HR. That is training staff. I have done a benchmarking with ESCOM and SAB academies. And I propose with regards to the PIC, because of the nature of the entity, that the PIC learning and development in respect of regulatory work fall under regulatory compliance, and there be a dedicated team for proper coordination in that regard. I propose digitalization, including e-learning. It may be necessary in order to implement this to have a task team. Other institutions have done an international benchmarking. PIC needs to do their own analysis through a task team and do that international benchmarking and come up with a proposal for the PIC. That's my proposal, Commissioner.
With regard to your proposals, where you've done some analysis or analyses, are you prepared to make those available to us?
I've been engaging with people, and my conclusion is that, I spoke to banks, financial institutions. Some of them have done their own, so I have not seen their paper, but I've been engaging very widely in that regards. My conclusion is that PIC is a special dispensation. Perhaps the process for compliance should also be considered in the process of the PIC bill, that it should be clear and succinct because of the nature of laws that apply to us, what regulatory compliance should entail with regards to the PIC. Perhaps in the regulations to the PIC Act.
I'm now not sure whether you say, no, I can't make those analyses available, or I can.
I have been engaging, I've done my own analysis, yes. I propose a task team which will look at it. But PIC should do their own.
If we are to make recommendations based on what you tell us, then we must be able to say why this is proposed.
I think what the Commission needs to know is PIC regulatory framework currently is not working, and there needs to be urgent changes. ACC, I don't think are prioritizing it. In fact, I don't attend it, but what I consistently get as feedback is change your report, but change your report on the basis of what? What strategy, which has not been considered.
I think what the Commissioner is really after is, have you done any analysis and research on the subject that you can present to the Commission to assist them in their work to make recommendations to the President?
I have engaged with people from financial institutions, including banks, some of whom have done their own research. And after engaging with them, I have come to the conclusion that PIC regulatory framework is not supported globally. And urgent steps need to be taken in that regard. In whatever format, my proposal may or may not be taken into account. But I mean, there's about 2 of us within legal who, including myself, who's senior manager, who work on pieces of legislation. We are struggling to find time over and above our other legal work to do a section-by-section analysis of pieces of legislation. And therefore, I propose a dedicated team which will look at it, whether it falls under us or in compliance, but there has to be a dedicated subject matter experts who will make time to go through that.
I think I hear you. I think I hear you. Where you can't give us an analysis, are you saying that no. we should propose
it's me who
that
have
the team look at it? I would have thought, having engaged with whoever you engaged with, you made yourself some notes and you said, this can't work, this is what I got from this person and this is what I got from this person, and I think it's a good idea. I don't think it's a good idea.
I don't know if they would want me to disclose. I had spoken to them in good faith because that's the strategies of their companies.
That's fine, but you can delete the names. Okay, you may proceed.
I want to conclude. I have listened to the testimony of others at the Commission. And my intention initially was that my story is so minute, I don't think it should be told. But as people were testifying, it brought back memories and in a way prompted me to come here. I agree with that the 2 chiefs at the PIC were powerful, too powerful beyond words. I agree with the previous speaker, Nomsa Mopeche, that they destroyed destinies. Yes, there were elements of victimization of employees. I have seen employees become very sick and leave the PIC, some without a job. I am speaking for those friend colleagues who suffered and left. I still remember one of the employees who I shall not name but left for an international job, shattered and broken when I met him in the lift, and he was stating categorically, and he was very angry, that this is not a government institution, this is not their company. Shortly thereafter, he left the PIC. I have been spied on without due notice as required by law. For me, this was random, and there was no basis for the top to do that. I was far removed from the investment transactions which were the subject matter of media scrutiny or any deals for that matter, as my main focus was corporate legal. The PIC and the top knew that I'm a highly ethical professional, and I could not have been the cause of those leakages at the PIC. The only basis in my view was to find something which they could use to nail me, and they failed. And I want to believe that the top 6 list could have been sanctioned at the top, at the board. South Africa now know me as a victim, and I want to say to South Africa, I refuse that label. I am no victim. They tried to break me, and they failed. And I kept my head high and carried myself with dignity and continued to do my work diligently and with high levels of ethics. I continued to fight to the end for what is right without fear. I have tried to rationalize the conduct of the top towards me. I cannot think of a single reason why board and top executives would exclude a capable corporate lawyer, a leader who successfully managed a legal team. The conclusion that I have come to is it is not really about me, and in fact, there is nothing wrong with me. But they try to appoint somebody who will support their decisions, somebody like Nesani, anybody but me. Somebody last week said to me, since you were removed, there has not been law practiced at the PIC. Pam, go to the commission and state your case. You were once also company secretary. Yet another lady recently commented when they appointed Tlamini, by far a junior, and when I was mentioned at the commission that, Pam, don't worry, be strong. Some of us women are in awe about your strength and draw strength from you, and we women of the PIC want to be like you. Another one last week said to me when I was catching up with her after some time that, Pam, some of us have seen you go through the worst of challenges and torn apart, yet you became stronger and happier. And I want to state to the PIC that I'm not breakable, I am simply unbreakable. To Dr. Dan and Matsepo and the board members who supported them, you tried to break me and you failed, and I'm still here when there's a cloud over your heads. I'm confident that the PIC will recover and that the new era shall bring a new dawn. And that concludes my statement, Commission. I started with my point. I concluded that, yes.
Thank you, Mr. Commissioner. That is the evidence.
Advocate, can we check with the company secretary whether the issue of spying on the individuals who've been named not only by the current witness but previously in our testimony ever went to the board, the Directors' Affairs Committee, or any individual of the board? So that, was it simply the management who took that decision, or was any individual board committee, Directors' Affairs Committee, board as a whole, aware of, endorsed, in whatever way you want to put it, so that there isn't a question that said, oh, you didn't ask me exactly that, of that decision to spy, or the outcome of that?
It is noted and it will be reported.
One or two questions. When all this stuff was happening, were your bands changed, bonuses, structures, LTI, the STI issues?
My salary remained the same, but I feel my bonuses were much less than what I got at the beginning when I started at the PIC. It got lesser and lesser. In my view, the bonus review evaluation process is very subjective. It depends who likes you, who doesn't like you.
And I think you pointed out I think it's 11.8 that you think there could be a new dawn. But from here, where are you now? I mean, are you happy now or are you still unhappy? And how is the relationship with the others, Setsedi and Dlamini and the others? Because you work in the same team,
We work in the same team by name, but we are very fragmented. Many people not talking to each other. So you do your own thing, there's no meeting, so we never know who's thinking what, who's doing what at any given time at the legal department. So legal department is not in unison. A legal department should be a hub of activity, of people engaging, putting their minds together on issues of the law. Certainly the opposite of the PIC for many years now. Am I happy? I've never allowed myself to be, not to be happy. I've continued to do my work.
You have also mentioned that this position has now again been advertised, the executive head legal, and you have applied for that.
I've applied for a position that is mine.
And you will be interviewed for that position?
They were moved from Friday. I'm meeting them today at 3 o'clock.
I suppose you do realize, of course, that the bonus pool have been dropping in size, haven't you? Isn't that why your bonus has not been what it was before?
Well, as an example, my rating was changed from a 4.1 or 4.2 to 3.6, and I think it's because of the legal views. There was nothing wrong or different with the manner in which I did my work. It must be the type of opinions that I've given or the type of actions that I've taken the past year. I never asked why, I just let it go. But it did affect my bonus at the end of the day.
So that is it. You will make available to the legal team the documents that you have been reading through. That is not in your statement. Okay.
I will do so, sir.
Yeah.
Thank you.
Otherwise, thank you very much for your time. Thank you for the decision to come and place some evidence before us as to what's happening in the PIC. We are not promising about your position, but it's part of our work to look at the governance within the organization. So you've helped us a lot with some of your evidence. Okay, thank you very much.
I thank you for the opportunity. Thank you.
And I hope if there is anything that we need you for, that you would be able to come back for whatever thing that you want clarity on. You'll be prepared to come back to us?
Anytime.
Thank you so much.
Thank you, sir.
Thank you. You're excused.
Mr. Commissioner, we're ready to proceed with the next witness, but perhaps we can have a brief adjournment before we do so.
Who is your next witness?
It's the witness Zonke, and it will be on the VBS matter, Mr. Commissioner.
All right, let's take a 15-minute break. 12:15.
Thank you,
Yes.
Mr. Commissioner. Our next witness, Mr. Zonke, is ready to take the oath.
Good day, Mr. Zonke.
Good day, Commissioner.
Can you stand up, please? Your full names are?
My name is Kaya Zonke.
I didn't hear.
My name is Kaya Zonke.
Kaya Zonke. Do you have any objection to taking the oath?
No, I don't.
Do you swear then that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you. You may be seated.
Mr. Zonke, you've prepared a statement from which you're going to be giving your evidence to the Commission on the VBS transaction, is that right?
That's correct.
And you do so in the context of what you do in your particular division, the Portfolio Management and Valuations Division, is that correct?
That's correct.
So you'll be taking the Commission through how you've monitored this particular investment at VBS.
That's correct.
Can you please get your mic closer? Advocate, yeah.
Okay. Okay, so can we begin in your statement from paragraph 1?
Thank you. Thank you, Commissioner. I'm an adult male currently employed by the Public Investment Corporation as a senior manager in portfolio management and valuations in Isibaya. I joined the PIC as a senior market risk analyst in 2012 after spending 3 years at the Reserve Bank as a senior analyst for market risk in the banking supervision department. I spent 3 years at market risk at PIC, first as a senior analyst and a manager before moving to Isibaya PMV as a manager in 2015 and as a senior manager in 2016. I have obtained the following qualifications: an MPhil degree, BCom honors, and a BCom degree, all from the University of Cape Town. I am going to move to the second part.
Mr. Zonke, Mr. Zonke, can you please explain what market risk is? What do you do there when you say you deal with market risk?
So that was my first position at the PIC. So our role had mainly had to do with listed investments. So it entailed, among other things, analyzing the risks in the portfolios. We looked at all types of risks, including market risk, credit risk, issues around derivatives, and we did a lot of stress testing on the underlying portfolios for the different clients, and we reported to the chief risk officer at the time. So that was my role when I joined. That's why I spent 3 years before moving to Isibaya as a manager in PMV.
Do you look at mandate risk?
Mandate risk or mandate compliance. There was a team that looked at that aspect of risk. Otherwise, market risk was not responsible for mandate compliance.
Just before moving ahead, for the sake of completeness, do you know which team was looking into that, into mandate compliance?
There was a team, I think it was called Static Data and Mandate Compliance under risk. Okay. On paragraph 3, I have been requested to give evidence to this commission relating to the VBS Mutual Bank, which I refer to as VBS. I set out below in some detail the role of the Portfolio Management and Valuations, PMV, division to give the proper context to our division's monitoring of VBS. PMV forms an integral part of the Isibaya division. Its primary responsibilities are to proactively monitor and analyze both financial and non-financial performance of ECBI investments through the deal life cycle. Some of the key functions of the department include, but are not limited to, actively monitoring financial performance and financial covenants of ECBI investments through the investment tenure of the investment, assess the quality of investment and detecting early warning signals of deterioration and thereby aid to minimize impairments. We provide early warning signals for possible distress scenarios to the relevant PIC governance committees and implementation of remedial actions. The team identifies triggers for distress and recommend distress companies to PMC unlisted for workout and restructuring. The team recommends investments to PMC unlisted for workout.
While we're here, Mr. Zonke, what's the staff complement? Who constitutes the team?
All right, thanks. I've already, I do have a section that deals with this. That's section or paragraph 22 to 24, which I will read. The department reports to the executive head, investment management. The department is made up of 1 senior manager, that's myself, 4 portfolio managers, 9 associates, and 2 analysts, which is a staff complement of 16. Currently, there are 4 vacancies, 1 for portfolio manager, 2 associates, and 1 analyst. And these positions were created by, there were resignations and a promotion. But we're currently filling these vacancies. I have been involved with monitoring of ECBI investments since 2015 when I was appointed to the role of portfolio manager PMV and later moved to a position of senior manager PMV. I have thus been involved with the monitoring of VBS since June 2015 when I joined ECBI PMV. The structure of the team is such that an associate is responsible for most of the monitoring work at an investee company level, and that includes compilation of reports for internal committees, client-side visits, liaison with the investee company, and any other related work. The portfolio manager is responsible for overseeing the work of the associates that report to them and to assist the senior manager with the unit's work. The senior manager is responsible for the overall work of the team, including coordinating internal committee submissions and presentations, stakeholder, both internal and external management, client engagement, strategy for the unit, and more importantly, to provide leadership to the unit.
Okay, so we're going to go back to paragraph 6 of your statement, having covered the department. But while we're also here, Mr. Zonke, can you give the Commission a contrast with the listed department, the listed division in relation to monitoring investments? How does that happen?
Thanks. So the investment process is slightly different between the 2 divisions in that within unlisted, I've actually attached the investment process here for unlisted investments. It's different in a sense that in the unlisted investments, a deal maker or a transactor, they originate deals, and mainly these are unknown unlisted companies, all the way through exit, right? And the difference is that in listed investments, most of the investments or the companies they analyze are listed, and in most instances, there are no intentions to exit. So for unlisted investments, the process is such that a transactor will take the transaction from initiation up until it's approved by relevant committees, and that is and after that the transaction is handed over to support functions that that will monitor the investment. But that does not mean that the transactor divorces himself or herself from the transaction. They are still part of it, but the heavy lifting, is transferred to another division, which is PMV and ESG. And most of the work post the first disbursement is done by those two teams. I think the difference, Commissioner, is that the intention in the unlisted space in the main is that the deal life cycle is different in that there's origination up to exit, whereas in the listed space, in most instances, there's no intention to exit.
Thank you. Let's move on.
Yeah. If you could just give us the picking order, who do you report to? Is that the GM and then the executive heads? Just give us a sense there.
Right. I report to the executive head, investment management. There's no general manager in our division. And I think she reports to the CFO.
Okay, paragraph 6.
On paragraph 6, our involvement in the ECBI investment process or deal life cycle is demonstrated by the diagram sourced from the PIC's investment process for unlisted investments. So I've attached this diagram so as to demonstrate exactly where PMV gets involved. As you'd see on the top left, there's an arrow which shows that PMV team gets involved at handover.
So that's where the heavy lifting begins.
In the
as
main,
you described.
Exactly. In the main, in that the transactors, after approval, right, they hand over the investment to supporting units, which is post-investments, PMV, and ESG, right? And from there, most of the work that's done, and that also goes through committee submissions, it will be done by the PMV team. But of course, the transaction team will always be part of that particular investment. So what I'm trying to demonstrate here is exactly where the team gets involved from the meeting handover up to exit. So if I may move on to paragraph 7.
Just before you do, if I can just refer you to paragraph 5. You are speaking of 5A, where you speak of financial covenants. What does that mean? Can or must be done and mustn't be done, or things that need to be adhered to?
Thank you, Commissioner. Financial covenants are mainly risk mitigants in these transactions, and in companies are meant to adhere to. So what the team does is an assessment. Firstly, we get a covenant certificate from the company itself that will confirm if they still meet our financial covenants, and the associate or the person responsible for it will go through it to analyze if it is actually indeed the case. So it's something that these companies are meant to adhere to. Correct.
Okay, let's proceed. Paragraph 7.
So from paragraph 7, once all CPs have been met, a process run by the legal team. The legal team prepares and issue a legal condition precedent satisfaction letter to the client serving as a confirmation that all CPs have been met and that the agreements are now unconditional. After the finalization of legal agreement, a handover meeting is convened by the investment management operations team, where all relevant stakeholders, including PMV, investment finance, investment teams, ESG, legal, and risk will be invited to the meeting. The purpose of the meeting...
Just a question to take you back to my question earlier. In terms of the structure, I just want to understand, a senior manager and a general manager, are they same level, same pay grade, so to say?
I don't know.
Okay. Because in the listed section, it seems there's a general manager before the executive head, and in your division is the senior manager and the executive head.
Correct, Commissioner, that's the structure in our team.
Yeah, okay, all right.
We're at paragraph 8 of your statement.
Right, thanks. The purpose of this meeting, the handover meeting, is to appraise all relevant internal stakeholders about the transaction, where the structure of the deal and investment fundamentals are explained by the investment teams, to ensure common understanding and to clarify any transaction-related issues. Once the handover process is complete, the transaction will move to the disbursement process. Following completion of the handover stage, the investment team, assisted by the ECBI operations team, prepares a disbursement file. The initial disbursement file will be prepared in line with the disbursement checklist, which is signed off in line with the delegation of authority. Once disbursed, the transaction moves to the post-investment monitoring teams, which includes PMV and ESG. For subsequent disbursements, the ECBI operations team is responsible for initiating drawdowns upon receipt of drawdown or utilization requests from the investee companies.
So in other words, when dealing here with VBS, they would make their drawdown requests in respect of the 350 million revolving credit facility. They would do that with you, with the PMV department.
All right, thanks. No, the process is that the request will go to the investment operations team. So the team, I think Silo when he was here, I think he explained what they do and what they will check. So it will go through their team first, and they will check what they need to check, and then process the drawdown. The drawdown will come to our team, because we also check, we also signatories to the subsequent drawdowns. So we'll also confirm that the conditions have been met. I'm on paragraph 14. Post disbursements, the transaction is monitored and reported on by PMV, ESG, and investment teams until exit. PMV prepares an investment report based on the approved structure, which includes financial performance, risk rating, and any other monitoring aspects of the investment. The portfolio reports are prepared on a quarterly basis once information from investee companies has been received, for submission to Finance and Valuations Committee and subsequent committees as per the delegation of authority. On paragraph 16, all ECBI investments are risk rated quarterly. The portfolio is disaggregated into 4 categories, namely performing, underperforming, watch list, and distressed in accordance with the internal risk classification criteria. Performing investments are those performing in line with expectations and do not exhibit significant deviation from base case assumptions. Furthermore, these companies show no observable signs of the client's investment to be at risk. Underperforming investments are those performing below expectation and have significantly deviated from base case assumptions. These investments depict material adverse change to key financial performance measures, such as, but not limited to, EBITDA margins, changes in working capital, and changes in capital structure. These investments usually require performance improvement initiatives to improve revenues, margins, and profitability. And this leads to a close and ongoing interaction between the company's management and the PIC. And mainly the discussion with regards to underperforming investments is with management of these investee companies, but it will be reported to PIC committees on a quarterly basis. On paragraph 19, watchlist investments are those investments that depict early signs of distress that are characterized by high debt levels, declining revenues, increasing overheads, loss of competitive edge, among other factors, and other qualitative factors. There are other several material factors such as, but are not limited to, breach of covenants, default on payments, and force majeure events that are considered as triggers for classification under watchlist. Distressed investments are those investee companies that are reasonably unlikely to pay their debts and when they fall due or will become insolvent within the immediate ensuing 6 months, or have their fair value of its liabilities exceeds its assets, and other several triggers.
When you speak of triggers, Mr. Zonke, is there a criteria that triggers these criteria which we can submit to the Commission and which detail each one of these categories?
All right, thanks. We do have an approved criteria that we have submitted, and it was approved by PMC, which we'll be happy to share with the Commission.
I confirm, Mr. Commissioner, that we will obtain that document that speaks to this classification.
So you're not able now just to summarize?
I can provide it, Commissioner.
Can you? No, I mean, now that you are giving evidence before us, are you unable to summarize for us?
Oh, the triggers? Yes,
Yes.
I can.
Please do.
All right. I'll go back to underperforming investments because there are several triggers under performance. There are about 15 triggers for watch list, and there's about 8 for distressed investments. So I'll take you through all of them.
Are they different?
Yes, they are different.
Yeah. The distressed investments one
Right.
now, and then you can give the rest to council.
Thanks, Commissioner. One of the triggers we look at for distressed investments is material adverse events in these companies. Impairments of the debt instruments. We look at whether or not the company is likely to be placed under business rescue or there's a pending liquidation application. We look at if, for instance, a company is about to has lost its operating license. We look at if the company has failed to redeem the pref shares or its debentures to the PIC or other debt holders. We look at if the company intends, for instance, to seize a big portion of its operations, then we deem that to be distress. So there's quite a number of them. There's about 8 under distress, like I say. But for watch list, it's about 15, and there's about 5 for underperforming, and that we'll share with the Commission.
Okay, it's just the last sentence of your paragraph 20.
Paragraph 20, right. I'm still reading on paragraph 20 under distressed investments. Again, what we assess, if there are observable signs that the client's investment is at risk and there is a reason to doubt the recoverability of the invested capital, if a turnaround strategy or restructuring is not commissioned. So with these distressed investments, it's not an indication that these investments are written off. It's a classification such that the interventions that we put in, if successful, we're able to turn them around, and they are rated differently.
Now, while we're here, Mr. Zonke, can you tell the Commission what happened in relation to VBS? Under what categories did it fall? And yes, so what happened there?
Thank you. So with VBS, it was excuse me. It was one of those scenarios that will happen once, right? I mean, this investment was rated green, i.e. it was performing in line with the expectation until the liquidity crunch. So it moved from performing in line with expectation to distressed. So it didn't move between performing, underperforming, watch list. It skipped underperforming and watch list and all the way to distress.
And what was the cause for that?
So the cause for that, throughout our monitoring of the company, we were quite happy with the performance. I mean, the issues, we started raising issues in around October 2016, when we saw that the municipal deposits were declining. And we actually sent a question to the CFO, and the question was actually answered. And the response we got was they typically, would get municipalities withdrawing funds close to their year end. And they will replace those deposits once they close their year end. And that was the response. And that happened around October 2016. We do have that response in writing, I think, from the company itself. So at that time, the company was doing well. We supported their strategy. I mean, among other things, I remember a meeting we had with the company in 2016 outlining their 5-year strategy. That among other things, they want to move from being a regional bank to a national bank. They want to move from being a mortgage bank to a corporate and a retail bank. And to that end, they had raised about 360 million from 3 municipalities, 350 million from the PIC. And they're in a process of approaching other targeted clients, such as taxi unions, churches, SMEs, and the general retail clients. And we actually supported that strategy. We thought it's something that could work. And they had actually demonstrated that they were actually, on their way in doing that. I mean, the initiatives that they put together, and that was reported to us, they were quite good. They'd opened a corporate office here in Joburg, in Rivonia. They had opened a branch in Joburg CBD. They actually started with internet banking. So for us, all those signs were very good signs of a bank that wants to that wants to expand and want to do the right things. So it is because of that it was rated as a performing investment.
Were you aware at the time that municipal deposits were not legal? And you said they raised 350 million. Was that not a very specific revolving credit facility that had been earmarked for certain types of activity?
Yes. Thank you, Commissioner. The 350 indeed was for the fuel facility that was raised from the PIC.
Just the fuel facility, not general contract facilities with government?
Yes. And they had raised about 360 million from 3 different municipalities at the time. I think they had raised about, I'll quickly check that. At the time, they had raised about 160 million from Vembe, 60 million from Capricorn, and another 146 million from West Rand.
But were you aware that that the municipalities were not allowed to invest into a mutual bank?
All right, Commissioner, we were not aware of that at the time. And we could not think that they were not allowed to deposit because the bank was specifically targeting municipalities as part of their growth strategy. So we thought that it's something that was legal.
I note that you mentioned churches. Do they have money?
Indeed, they mentioned that they wanted to target churches, among other things, independent African churches, unions, tax associations, stockfells, SMEs, and quite a number of clients, including the public sector. I mean, when they gave us the 5-year strategy, they called it Strategy 2021. They wanted to increase to their balance sheet to grow to a region of 11 billion rands. And they, from that 11 billion rands, about 5.5 billion, the target was churches, unions, tax associations. So a huge portion of that, in fact, they wanted to raise it from these institutions.
No, I just wondered because my church is very poor.
Let's continue from paragraph 21 of your statement.
Right. On paragraph 21, I just wanted to highlight here that valuations, the independent valuations are done by finance valuations team at the PIC. And this is done on a quarterly basis, and it's done for 3 quarters, and at year end it's given to external companies to do an independent valuation. And it's usually the big accounting firms and other companies that are qualified to do this kind of work. I've already dealt with paragraph 22 up to 24. I would move on to paragraph 25. On the 8th of February 2017, we sent a letter of demand to VBS for an outstanding amount of 36,626,036 rand and 56 cents in both capital and interest as at 31 January 2017 on the 350 million revolving credit facility.
Exactly. Do you remember the date when the revolving credit facility was granted?
I don't remember the exact date.
The month.
The month
and year of granting the revolving credit facility.
Okay. I think I do have it somewhere here.
Perhaps continue and we can find that and
Okay.
just provide it.
All right. VBS duly complied and paid the outstanding amount on the same day. I have attached both the letter of demand and proof of payment as Annexure F25 and F27.
So, in the documents which have been submitted to the Commission, Mr. Commissioner, it's tab F25 and F27.
We issued another letter, but this time it was a letter of notification for outstanding management accounts and overdue quarterly meetings on the 3rd of March 2017, as VBS was in breach of the obligation set out in clause 10.1.1 up to 10.1.5 of the loan facility agreement. And I believe the agreement is also attached.
The final or executed credit facility agreement appears at tab number 10 for the record, and those clauses appear pages 20 to 21, Mr. Commissioner, of the document starting in tab 10.
All right. On paragraph 28, continue. VBS main shareholders, the GPF, held a 25.26% stake, Jambeu Investments 25.22%, and various organizations and individuals held about 49.51%.
Can you tell us who Diembo is and the various organizations and individuals?
I can provide, I actually don't know who Jambeu Investments, and the other organizations and individuals, I don't have specific details, but I can provide that information to you.
I think it's important.
Noted, Commissioner, we'll provide the...
So these were shareholders before the company embarked on a long-term capitalization strategy. And I think this links to what I mentioned earlier, the strategy 2021. That's when they first started with the rights issue. The first rights issue was approved by a special general shareholders meeting in December 2015 and was implemented in March 2016. At the time, Vele Investments did not own shares in VBS and subsequently held 5,100 shares to the value of 51,100 after the first rights issue.
Sorry, can you explain how, if there's a rights issue, first rights issue, how a company that does not own shares gets shares? I would have thought the rights issue is for existing shareholders to follow their shares, their rights to acquire more shares. So how would Vele and who Vele is obtain those shares, and at what value the shares were, and did money actually arrive in the account? If you've bought that amount of shares, 5,100 shares to the value that is there, so much per share, who Vele is, how they followed their rights when they didn't have any shares in the first place, and whether the actual money was paid into the VBS account.
Thanks, Commissioner. The issue around Vele was very problematic to us in that we asked for a registration of shareholders from the company. We wanted to find out exactly how this entity came from zero shareholding to, I think at the time they held about 4% after the first rights issue. And after the second rights issue, they were majority shareholders in the business. We expressed our concerns, and management actually never responded to our concerns. They never gave us the share register, and it's something that we requested for the longest time. And to answer the question around whether the money was paid for the shares, Commissioner, I actually don't know if the money was actually paid. And from PIC's perspective, it would be difficult to verify if money is paid by either Vele or the individual shareholders when they were exercising their rights.
But you have two members on the board who are there to represent the shareholder, and I would have thought it is a very simple question to ask representatives at PIC, how does somebody follow their rights when they don't have shares in the first place, and did the money get paid? Surely your CEO should have said, you raised the concern, he's written a letter before in relation to what you pointed out here, in terms of management accounts and in paragraph 27. I would have thought you'd want to know how somebody becomes a shareholder following rights when they don't have a share in the first place, and then the PIC's shares get diluted. It doesn't make much sense to me that you can't get that information.
Thank you, Commissioner. Our shareholding was not diluted because we followed our rights. But
the time, because elsewhere I seem to have read that you did it later, that you weren't notified.
Yes, yes.
So it was done later?
Yeah, it was done later.
Why would you have not been notified if it's a board decision to issue shares?
So, Commissioner, these are the issues that we've had with the company.
But did you raise it with the CEO, and was it raised with the board?
It was raised with the board.
Yourselves or by the CEO?
Well, I wouldn't say not to the board, let me correct that, but it was raised to the CFO, because CFO would issue all the shareholders' communication, right? So would raise that with the CFO, and that was our context in the VBS. So would raise all these issues, and he had all manner of excuses on why we did not get notification, ranging from sending it to wrong people and trying to correct that and trying to find out exactly who they should be sending such communicate to the PIC. So these issues were raised at stages, both first and the second rights issue.
And within the PIC, who did you raise it with? The question, given the problems that you were experiencing, how was it escalated within the PIC, given that your head of risk and your head of legal are on the board?
Yeah. Chair, from the post-investments team, an oversight from our in that we did not have a formal session where we would go to either the head of legal or the head of risk where we had concerns. We expressed our concerns to firstly the company via the CFO, and to not to the direct individuals. So everything that we experienced, all the problems that we had, were raised through our internal committees, through the portfolio management committees for unlisted investments.
And perhaps would it be a question that said, if you would normally do that through risk and legal, the question would be those very people are sitting on the board, so they either should have been able to answer you or there would have been a conflict of interest.
Correct, Commissioner, because the two individuals were actually, they were part of PMCs that sat on these issues that we would have raised. But I don't recall these two individuals responding to any of the issues we had.
Then just in relation to paragraph 28, if we can follow up with exactly who Diambo Investment is, the various organizations and individuals, and whether Vele had the ability to follow or to obtain shares in a rights issue where they had no shares in the first place. And finally, in relation to that, what price they paid and whether that money was actually deposited into the VBS account.
Noted, Commissioner, we will do so.
Paragraph 29. The Board of Directors resolved to embark on a second rights issue.
When was this in relation to the first one?
This one,